Frequently you will find a situation where a person's loved one becomes totally incapable of managing their affairs, either because of serious illness or some other condition. And because that particular person did not have a power of attorney in place, or if there are other circumstances that require it, a family may require the court to appoint them the guardian of their loved one. In Pennsylvania, a guardian is a person appointed by the court to manage the financial and medical affairs of the person as the circumstances permit. There are many types of guardians that the court may appoint. Probably the most common that we see is what's called a plenary guardian. A plenary guardian or a plenary guardianship refers to a situation in which the court finds that a person is totally incapable of managing their medical and their financial affairs, to a point that a guardian is required essentially in perpetuity to handle those affairs for that loved one. What we try to do is we try to assist clients who have loved ones who require guardianship services in several ways. First and foremost, we try to meet with the client and prepare the necessary petition to the court that requests their appointment as guardian over that loved one. Secondly, we work with the physician that has treated their loved one in an attempt to obtain that physician's testimony in support of the petition for guardianship. Third, and most importantly, we work with the loved one after they have been appointed by the court as guardian to make sure that they are following the court's directions as to reporting requirements. The guardian must report on an annual basis to the Court of Common Pleas whatever measures they have taken financially and medically on behalf of their loved one. In addition, there are other circumstances that require court approval prior to the guardian taking certain types of actions. We work with the clients to ensure that they are following these requirements. And in addition, we work with them to make sure that they are properly representing the interests of their loved one. Oftentimes we remind clients of this and encourage them, when they are still able to handle their affairs, the importance of making sure they have such estate planning documents as a power of attorney and medical directive in place to avoid this unfortunate result if such documents do not exist.